Companies Act, Section 378, Interpretation and Continuity of Prior Winding Up Laws. Section 378 of the Companies Act, 2013, is a saving provision that ensures continuity and proper interpretation of earlier legislation or legal instruments that conferred powers to wind up certain entities such as partnership firms, limited liability partnerships, LLPs, societies, cooperative societies, associations, or companies under earlier corporate statutes, including the Companies Act, 1956. This section ensures that even after the enactment of the Companies Act, 2013, the provisions of other laws or enactments that authorize the winding up of such entities remain valid and unaffected. It also provides guidance on how to interpret references to the repealed Companies Act, 1956, in such laws. Preservation of earlier enactments allowing winding up. The main body of Section 378 clarifies the following. Nothing in this part, i.e., Part 2 of Chapter 21, of the Companies Act, 2013 relating to the winding up of unregistered companies shall have the effect of nullifying, amending, or invalidating the provisions of any earlier special or general enactment that allows a partnership firm, a limited liability partnership, LLP, a society, a cooperative society, an association, or a company to be wound up under the Companies Act, 1956 or under any earlier act that was repealed by the 1956 Act. In other words, this section ensures that special powers or procedures laid down in other laws that permit the winding up of these types of entities continue to remain in force, even though the Companies Act, 1956 has been replaced by the Companies Act, 2013. Proviso, Interpretation of references to repealed acts. The proviso to Section 378 provides an essential interpretative rule. If any existing enactment, still in force, makes a reference to a specific provision in the Companies Act, 1956, or in any earlier act repealed by that 1956 Act, such references should not be deemed obsolete. Instead, such references must be read and interpreted as references to the corresponding provisions, if any, that are now contained in the Companies Act, 2013. This ensures continuity and legal clarity, and prevents legal provisions in other laws from becoming ineffective merely due to changes in the structure or numbering of corporate legislation. It also maintains consistency in legal interpretation, especially when old enactments have not yet been updated to refer to the new Act. Purpose and legislative intent. A. Preservation of legislative intent. The section aims to preserve the powers granted by other statutes, especially those laws that allow winding up of non-corporate or hybrid business entities under the framework of earlier Companies Acts. B. Smooth transition to the 2013 Act. It provides a mechanism to transition smoothly from the Companies Act, 1956 to the Companies Act, 2013, by ensuring that statutory references to the old Act do not become invalid, but are instead redirected to the equivalent provisions in the new legislation. This avoids the risk of legal uncertainty or procedural gaps in the winding up of partnership firms, LLPs, or other associations, where the power to wind up was rooted in the now repealed Companies Act, 1956. Implications for legal interpretation and practice. Legal practitioners and adjudicating authorities, including the Tribunal, NCLT, must continue to apply the winding up powers granted under earlier legislation, even if the underlying reference was to a repealed Companies Act. In practice, any references to the Companies Act, 1956 in such laws must be construed harmoniously with the provisions of the Companies Act, 2013. This provision prevents the need to amend every single law or statute that referred to the 1956 Act and ensures that legal rights and remedies remain intact. For more details, contact us.